Space Cafe. News, music, and comedy.
Annual resolutions referred to in that passage can be traced as far back as February 21st, 1700, when the English House of Commons adopted at page 350 of the Journal a resolution, quote, that if it shall appear that any person hath tampered with any witnesses in respect of their evidence to be given to this House, or any committee thereof, or directly or indirectly endeavored to deter or hinder any person from appearing or giving evidence, the same is declared to be a high crime and misdemeanor, and this House will proceed with the utmost severity against such offenders, end quote.
Don't forget to like, dislike, subscribe, and comment. Safe Space Cafe. And always, have a good day.
And this House will proceed with the utmost severity against such offenders, end quote. Which is equally applicable in this separate question of privilege. From the list, which I had mentioned, can be found at page 82, I would refer the chair to the 11th and 13th items. Quote, interfering with or obstructing a person who is carrying out a lawful order of the House or a committee, intimidating, preventing, or hindering a witness from giving evidence or giving evidence in full to the House or a committee, end quote. Clearly, Madam Speaker, Messrs. Tice, Singh, and Chin were prevented from, and maybe even hindered in their ability of carrying out a lawful order of the House of Commons, namely giving evidence to the Ethics Committee. For his part, and this House will proceed with the utmost severity against at page 240 offenders, obstructing, interfering with, or preventing execution or orders of the House of a committee would be akin to aiding and abetting a person to commit an offense. Taking action to prevent an order of the House from being carried out could result in contempt because it also represents an affront to the authority of the House, end quote. McGee's Parliamentary Practice in New Zealand, 4th edition, states at page 774, quote, any attempt to intimidate, prevent, or hinder a witness from giving evidence in full to the House or a committee may be held to be a contempt. Such intimidation or hindrance may be overt. For example, physically preventing a witness from attending and giving evidence, or less overt. For example, offering a bribe to give false testimony or taking legal action to prevent a witness from giving evidence or from producing all the evidence in his or her possession, end quote. Page 1080 of Boskin Gagnon adds, quote, tampering with a witness or in any way attempting to deter a witness from giving evidence may constitute a breach of parliamentary privilege. Erskine May, at paragraph 15.21, declares, quote, any conduct calculated to deter prospective witnesses from giving evidence before either House or a committee is a contempt, end quote. The same point is also made in paragraph 38.59. Erskine May expands upon the concept at paragraph 15.22, quote, a resolution setting out that to tamper with a witness in regard to the evidence to be given before either House or any committee of either House, or to endeavor directly or indirectly to deter or hinder any person from appearing or giving evidence is a contempt, was formally agreed to by the Commons at the beginning of every session. However, following a report from the Procedure Committee which concluded that the sessional passing of such resolutions, although they had some value as statements of intent, did not add anything to the House's powers to deal with contempt, or, in the case of tampering with witnesses or the giving of false evidence on oath, the relevant statutory powers. The House agreed in 2004 to dispense with them. There have been, in the past, numerous instances of punishment for offences of this kind. Corruption or intimidation, though a usual, proceed with the utmost severity against is not an essential ingredient in this offence. It is equally a contempt to attempt by persuasion or solicitation of any kind to induce a witness not to attend or to withhold evidence or to give false evidence. This matter was considered in 1935 by a committee of the Commons, which reported that in its opinion, it was a breach of privilege to give any advice to a witness which took the form of pressure or of interference with their freedom to form and express their own opinions honestly in the light of all the facts known to them. And the House resolved...